The Colorado Supreme Court ruled this week that a workaround used by legislators to distribute funding for K-12 education is indeed constitutional. The decision stems from a lawsuit claiming that lawmakers violated Amendment 23, which requires school funding to increase with inflation and enrollment growth per year. Craig, you're one of our two esteemed lawyers at the table today. You can help explain how this lawsuit went down and really what it means for Colorado education funding.
Well, part of it is legal, and then part of it is political. And it's funny how the liberals always come out the way that big public school viewpoint dictates, and vice versa for the conservatives. And then if you look at the makeup of the Supreme Court and the way they broke down, our friend Rich Gabriel was just appointed to the Colorado Supreme Court. He voted with Will Hood and Monica Marquez, liberals appointed by Democrats, John Hickenlooper, but Brian Boatwright made the difference, a Republican appointed by John Hickenlooper. He was part of the majority, the four, in an opinion led by Nancy Rice. So it's like the Lobato case where public schools fought for more funding. It comes down to the base amount and whether you can take away from the supplement to the base amount. And the four said you could, and the three more liberal members said you can't. So it's interesting how, depending on your political perspective, your legal analysis seems to be changed.
Well, Penn, then I'll throw it to you for your legal analysis,
Sure.
regardless of where you're at politically. What did you make the decision?
You know, this is an interesting case because it really was a procedural decision, but it brings about a substantive effect. Real quickly, people had filed suit to challenge the negative factor in the school finance formula, saying that the way the legislature put the negative factor into law and applied it undercuts and violates Amendment 23, which was passed in 2000 by the voters to increase funding for public education. When they filed the suit, the state moved to dismiss it, which is a procedural move that says if everything the people who filed the complaint said is true, under no theory of fact or law can they prevail. Court, throw the lawsuit out. The trial court said, well, no, we don't agree with that. I, the judge, think that there is a version, there are interpretations that they could prove their claim that this is unconstitutional, so we go to trial. It then went up to the Supreme Court under what's called original jurisdiction, and the only question before the court was whether to overturn the trial court's decision to not dismiss the lawsuit summarily or to order the court to dismiss it summarily. What's sort of the extraordinary effect of this decision is on a split vote of 4-3, the state Supreme Court ordered the trial court to dismiss the suit summarily. And in doing so, what they essentially said is that the lawsuit as framed, even if you give the benefit of the doubt to the people who filed the suit, there is no interpretation of fact or law that you can conclude that Amendment 23 has been violated. And I think that's extraordinary. I also happen, as Craig's theorized, disagree with that. Basically what the lawsuit says is even if you read Amendment 23 narrowly to say it requires an increase in base funding, what the legislature did by passing the negative factor is it allowed it to reduce overall funding for K-12 education. Because when Amendment 23 was passed, there was no negative factor. So voters who supported it knew that Amendment 23 was going to generally increase funding for all school districts over time. When the legislature changed the formula, they essentially undercut the effect of Amendment 23, which is what the challengers were claiming, and the court decided that doesn't matter. What only matters is technically whether the base funding was cut, and they ruled that it wasn't. So the lawsuit's going to be dismissed, but it's probably not the end of this fight.
Natasha, I'm grateful we have very talented, wise attorneys on our panel. I'm still a bit confused with the whole thing. I have to just be honest with you. It seems that it still comes down to that we saw a legal fight over Tabor a few weeks ago. We have a legal fight over Amendment 23. They didn't go the way that the folks who filed the lawsuits wanted them to go. Is there an appetite at Capitol Hill to address these as the legislature and not just as lawsuits?
Well, I think that again and again we're showing that particularly education issues end up in the courtroom rather than at the legislature. But it is befuddling to me because again and again Coloradan voters and just people in general seem to say, yeah, we care about K-12 funding, we care about K-12 education, let's find a solution to this, a big think solution that would work. And even when we do come up with something like that, like Amendment 23, then it starts to get sort of, stripped away a little bit, or there's changes, or, any economics professor, you don't have to be one to look at it and say, okay, well, Amendment 23 plus recession plus Tabor equals a problem. Something's going to give here, something's not going to be funded. And the problem with all of these discussions is that it moves away from talking about the kids, which is something I bring up again and again at this table. But, for instance, I'm a reader. In my house, I have a ton of books. I care about this. If that means that my child, when he walks into a education system, will have a better chance at being literate because of that mere fact, it seems a shame to me that our education system can't equalize that somehow. So it's in the midst of these, base funding, factor funding, negative factor, all of that. Okay, important discussions. But let's get back to what we're trying to do here, which is to educate our kids and prepare them for a workforce.
Patty, are we going to see anybody take this on as a law, or is it just going to be more lawsuits?
I think we will see some attempt in the next year or two to untangle some of the really, really sticky parts of the Colorado Constitution that we've added by Amendment 23, by the Gallagher Amendment, by the Tabor amendments that just keep the budget so tight and so you can't move things around. So even if you come up with a good educational plan, you might have trouble figuring out where to find the funds and how to adjust it. It's not just education, but education is the biggest chunk. So certainly now with the bipartisan group that is looking into Colorado's future, suggestions that need to be made, they are looking at is there the political and the public will to finally fix the Constitution and just take those knots out of it.